Welcome to the deep dive. Our goal today, to give you, well, the ultimate shortcut to really mastering the foundational legal landscape of the United States. This deep dive is definitely for the learner who needs to look past just the surface level rules and understand the entire architecture holding them up.
Yeah, think about it in your daily professional life, whether it's OSHA standards on working surfaces, maybe EPA rules on waste.
Yep.
You're dealing with the results of law.
Right, the end product.
Exactly. But our sources today, they push us to understand the engine, the thing that generates those results, the foundational principles, starting right from the Constitution, that create the why behind every single regulation you encounter.
And that's our mission here. We're breaking down the U.S. legal framework, starting with the constitutional bedrock, then moving through the power of the courts.
And then getting really practical.
Yeah, right down to the practical application of civil liability,
Mm-hmm.
especially, rules of torts. Let's unpack this crucial structure.
Yeah.
Okay, Section 1, the foundational bedrock, the U.S. Constitution. We all kind of know it was written to fix the problems, the weaknesses of the Articles of Confederation, basically to build a stronger, more unified nation. But legally speaking, it's like the source code.
It absolutely is. And while we often focus on that powerful preamble, establishing justice, promoting the general welfare, securing liberty.
An operational part.
Right. The real legal architecture, the nuts and bolts, are in the 7 articles.
Right.
And they immediately set up this crucial separation of powers.
And that separation is so critical because it dictates who makes the law, who enforces it, and importantly, who interprets the law we deal with every single day.
Precisely. So Article 1, that establishes the legislative branch. Our bicameral Congress, the House and Senate, this is the birthplace of all statutory law.
Okay, so the codified rules, the stuff in the U.S. Code.
That's it. The House starts revenue bills, the Senate approves treaties, tries impeachments. But the core function, translating national will into binding laws.
Then you jump to Article 2. That sets up the executive branch, the presidency. Here, powers vested in, well, a single individual.
But importantly, that power is deliberately constrained. There are specific grounds for removal, treason, bribery, or other high crimes and misdemeanors.
And the executive branch, its power connects directly to a second type of law, right?
Yes. Administrative law.
Yeah.
The president's authority lets them create federal agencies. Think OSHA, the USAPA.
The alphabet soup.
Yeah. And those agencies then generate just vast amounts of regulatory law. That's what you find codified in the Code of Federal Regulations, the CFR.
Okay, so Article 1 gives a statutory law from Congress. Article 2's agencies create administrative law. That leaves Article 3, the judicial branch.
Which establishes the Supreme Court. And it also gives Congress the power to create all the lower, inferior federal courts. This is where laws get interpreted and where precedent is set.
Now, shifting focus slightly, there's also the glue kind of holding this whole structure together between the states.
Right. Article 4, that governs state relations. Crucially, it ensures national unity through things like the full faith and credit clause.
Meaning states have to recognize each other's laws and court decisions.
Exactly. And the privileges and immunities clause, too. It promotes that national unity.
And the ultimate check, maybe, against states going totally rogue is in Article 6, the supremacy clause.
Yes. Which basically says the Constitution and federal laws are the supreme law of the land. They override any conflicting state laws.
Which is essential, I imagine, for having a consistent legal environment across all 50 states. You need that baseline.
Absolutely critical, especially for businesses operating nationwide.
So if this whole structure, this foundation, ever needs a serious update, we look to Article V, the amendment process. Why is this process so important for legal stability? Why make it so hard?
Well, because it's designed to be incredibly hard to achieve. Stability was the goal. A proposal needs 2/3 of both the House and the Senate. Or, alternatively, a convention called by 2/3 of the states.
Okay, that's already tough.
And then ratification requires agreement from 3/4 of the state legislatures or state conventions. Do the math. Just 13 states, maybe not even the most populous ones, can block any change.
Oh, yeah.
The founders built this foundation to last. They wanted stability, ensuring any major structural shift would be, well, an extreme rarity.
Okay, so we've got the rule book, the Constitution, and the structure for making laws. Now let's move to the arena where these rules get interpreted and applied to the courts. How does the system figure out which court gets to hear which case?
That's the fundamental question of jurisdiction. Basically, the court's legal authority to hear a specific case. We usually break it down into a few key categories.
Right.
First, is the court hearing it for the very first time? That's original jurisdiction. Or is it hearing it on appeal from a lower court? That's appellate jurisdiction.
And crucially, if it's an appellate case, the court isn't retrying the facts, are they? They're focused purely on whether the law was applied correctly the first time around.
Yeah.
No new evidence allowed.
Exactly right. Just reviewing the legal application. Then we look at exclusive versus concurrent jurisdiction.
Okay, what's the difference there?
Exclusive means only federal courts can hear it. Think cases involving the federal government itself or maybe maritime law. Concurrent means either a state court or a federal court could potentially hear the case.
So if it's concurrent, what pushes it into the federal system? It must need something extra, right? Something significant enough for federal attention.
It needs one of two things. Either it involves a federal question, meaning it deals directly with the U.S. Constitution, or a federal law, maybe like a civil rights violation.
Okay.
Or it needs diversity of parties. This means all the parties involved are from different states. And this is important. The dispute has to be worth more than $75,000.
So you need both the diversity and the dollar amount.
Correct. If you miss either the complete diversity or that monetary threshold, you're staying in state court.
Now, the ultimate power of the courts, this power of interpretation, wasn't actually spelled out explicitly in the Constitution itself, was it? It came later.
It emerged from, one of the biggest aha moments in U.S. legal history, the case of Marbury v. Madison back in 1803.
The famous one. Tell us about it.
So, quick background. President Adams made a bunch of last-minute judicial appointments, but the paperwork, the commissions, weren't delivered before he left office. Marbury was one of those appointees, and he sued the new administration to force them to deliver his commission.
Okay, seems straightforward enough.
But the Supreme Court, under Chief Justice John Marshall, did something really clever, maybe even a bit sneaky. It ruled against Marbury getting his commission. But, more importantly, in explaining why, it declared that the part of the Judiciary Act, the law Marbury was using to sue, was itself unconstitutional.
Wait, so the court just said a law passed by Congress and signed by the president was invalid. Doesn't that throw off the whole balance of power? How is that power even kept in check?
It established judicial review, the power to declare laws unconstitutional. It was a massive power grab, arguably. But the check is built into the system itself. The court has to wait for an actual case or controversy to be brought to them. They can't just proactively strike down laws they don't like.
Okay, they need a live dispute.
Right. And their decisions ultimately rely on their own legitimacy and, frankly, the executive branch's willingness to enforce those decisions. It's a huge power, but it's somewhat self-regulating.
And judicial review is fundamentally how the third type of law gets made. Case law. This is judge-made law, built from these judicial decisions.
Precisely. And case law operates under this core guiding principle called stare decisis.
Latin for let the decision stand.
Exactly. It ensures stability, fairness, and predictability. Courts are generally required to honor the precedents, the decisions set in prior similar cases.
We saw that pretty recently, didn't we, with the Sackett v. EPA ruling?
Yes, a great example. The Supreme Court laid down a new, much narrower definition of what constitutes navigable waters under the Clean Water Act.
And it was unanimous, too.
Right. That new definition now sets the standard. Stare decisis means future cases dealing with EPA's wetlands jurisdiction must follow that precedent.
Okay, since consistency is so key for case law, let's see how courts apply that consistency when they're defining core professional responsibilities. This brings us squarely into the world of civil liability torts.
Right. A tort is basically a civil lawsuit. A private party, the plaintiff, is seeking payment damages for some kind of injury or harm they claim was caused by another party, the defendant.
And this is where the theory really hits reality for businesses and individuals. But we need to remember that staggering statistic.
97% of legal cases settle. They never actually see the inside of a courtroom.
97%. Why?
Because the leverage, the power in those settlement negotiations is built entirely on whether the plaintiff can credibly demonstrate they could win in court. And winning a negligent tort hinges entirely on proving 4 specific elements.
Okay, these 4 elements are like the pillars of the case. The plaintiff must prove all 4 to even have a chance. If the defendant can knock down just one,
the whole case collapses. That's why they're so critical in negotiations. So what are they?
Let's list them.
First, the defendant must have owed a duty of care to the plaintiff. Like, a driver owes a duty of care to other drivers on the road. Second, the defendant breached that duty. They did something or failed to do something that a reasonably prudent person wouldn't have.
Okay, duty and breach.
Third, that specific breach must have been the cause of the plaintiff's injury or harm. There needs to be a direct link. And fourth, there must have been actual damage, physical injury, property damage, financial loss resulting from that breach.
Duty, breach, causation, damage. The whole negotiation really hangs on how strongly the plaintiff can argue they have evidence for all 4 points.
Absolutely. That's the battlefield.
And if they can prove those points or seem likely to, the case then moves to calculating damages. We often just think of damages as money to fix the loss, but there are different types, aren't there?
Yes, they're categorized specifically. Most commonly, we deal with compensatory damages. The goal here is literally to compensate, to make the plaintiff whole again by providing the financial equivalent of their loss.
And then that includes?
It breaks down into 2 types: special damages, which are the quantifiable tangible losses, think medical bills, lost wages, repair costs, and then general damages, which are harder to put a number on, things like pain and suffering, mental anguish, loss of enjoyment of life.
Okay. And then there's the third type, the one that often grabs headlines. Punitive damages.
Right. Punitive damages are totally different. They aren't about compensating the plaintiff at all. They're an extra sum awarded purely to punish the defendant for particularly bad conduct and, crucially, to deter similar behavior by them and others in the future.
And these are often tied to a higher level of fault, not just simple carelessness.
Exactly. Which brings us to a really critical exception, especially in the workplace: gross negligence.
Ah, yes. Most typical work-related injuries are handled through the standardized workers' compensation system, right?
Yeah.
Limited benefits, no fault.
Correct. It's generally an exclusive remedy. But if the injured employee can prove that their injury resulted from the employer's gross negligence, the door swings open to a civil tort lawsuit outside the workers' comp system.
And that's a huge financial risk for the employer.
Massive, because now you're talking potential compensatory and punitive damages. Gross negligence isn't just ordinary carelessness. It's defined as an extreme departure from the normal standard of care. It involves willful, wanton, or reckless conduct.
So more than just a mistake.
Much more. The plaintiff has to show the defendant consciously knew, or really should have known, that their action or inaction would probably cause harm. Think ignoring repeated documented warnings about a serious equipment failure that then injures someone.
That level of almost deliberate indifference.
That's the kind of thing that can elevate a standard workers' comp claim into a potentially huge punitive damages case in civil court.
That distinction between simple negligence and gross negligence is clearly massive for any operation.
Okay, let's pivot now. Let's move away from needing to prove negligence or intent at all. We're shifting into the realm of strict liability and vicarious liability.
Right. Strict liability is fascinating because in these cases, the defendant's level of care is basically irrelevant. The plaintiff does not need to prove there was a breach of duty or any carelessness.
So liability is imposed just because the activity itself is inherently dangerous?
Pretty much. Liability attaches simply because the activity or the condition is considered inherently hazardous. The law says if you engage in this, you accept the risk up front.
What are some classic examples?
Owning certain types of inherently dangerous animals, historically things like tigers, but legally often includes specific dog breeds like pit bulls in some jurisdictions, or engaging in what are called abnormally dangerous activities like using explosives for blasting operations. So if a blasting operation damages a nearby house, even if they followed every single safety protocol perfectly,
They're still strictly liable for the damage. Their carefulness doesn't matter. The activity itself creates the liability.
wow. That sounds like there's almost no defense possible, unless maybe some huge natural event intervenes, the whole act of God defense.
Correct. That is a potential defense, but its application is very narrow. The act of God, like a hurricane, tornado, earthquake, must have been truly unforeseeable in that specific geographic location.
So if you build something in a known flood zone and it fails during a predictable 100-year storm,
That storm wasn't unforeseeable. The defense likely won't apply. It has to be something truly extraordinary and unpredictable for the area.
okay, that makes sense. Now finally, let's touch on vicarious liability, which is also known as imputed liability.
Right. This is actually a type of strict liability. It holds one party responsible for the wrongful actions of another party, most typically holding an employer responsible for the actions of their employee.
Even if the employer themselves did absolutely nothing wrong or negligent.
Correct. The underlying idea or rationale is that the employer benefits from the employee's work, so they should also bear the responsibility, the liability, for harm caused by that employee while they're acting within the scope of their employment.
The classic example is maybe a delivery driver running a red light.
Exactly. If that driver causes an accident while on their delivery route, the company they work for is held vicariously liable for the damages.
Okay, but what happens if the employee deviates, strays from their assigned duties? Let's say a sales rep is driving to a client meeting but decides to stop for a 3-hour personal shopping trip way off route and then causes an accident. Is the employer still on the hook?
That's where courts apply the frolic and detour rule, or the deviation rule. They have to analyze whether the employee's action was just a slight deviation, maybe grabbing a quick lunch along the route, or a full-blown frolic and detour that was purely personal.
And how do they decide that?
They look at factors like the employee's intent, the nature of the deviation itself, and importantly, the amount of time and geographic distance involved in the detour. Stopping for a quick lunch might still keep the employer liable, a slight deviation.
But the 3-hour shopping trip?
That 3 hours of personal shopping, miles off the established route, that's much more likely to be deemed a frolic, a major deviation. In that case, the employer is often absolved of liability because the employee was acting purely for their own purposes, well outside the scope of employment.
Wow, what a comprehensive sweep of the U.S. legal framework. We've managed to map the Constitution's core structure, understand the legal ripple effects of that separation of powers. We definitely recognize the immense power of judicial review and the stability that stare decisis aims to provide.
Yeah, the consistency factor.
And then we classified the main ways civil liability works through negligence, that higher bar of gross negligence, and then liability even without fault, through strict liability.
Including vicarious liability.
Right.
I think the essential takeaway here, especially for you listening, is that just knowing a specific statute like an OSHA rule is, well, it's useful, sure. But truly understanding these foundational principles.
From the very top.
Yeah, from the power of Article 6 Supremacy Clause right down to the nitty-gritty rules of vicarious liability. That's what lets you genuinely anticipate and manage legal risk in modern operations. It's the difference between just, blindly following a rule.
And understanding the whole system that makes that rule legally necessary in the first place.
Exactly. Knowing the why.
Which leaves us with this final provocative thought for you to consider. We heard that overwhelming statistic, 97% of legal cases settle. They don't get decided by a judge or jury. Now, considering all the detailed requirements we discussed for proving intent or negligence or even strict liability, and considering the consistency promised by legal principles like stare decisis and due process, what do you think is the most significant factor that ultimately pushes parties towards settlement, rather than trusting the idealized fairness the court system is supposed to provide?
Good question.
Something to chew on. What do you think about that?